Brendan Dassey, trial transcript, day 5, continuing on page 53. Attorney Fallon. Yes, thank you, Judge, for this consideration. Our concern is simply this. We would object to any attempt by the defense to introduce other statements, arguably exculpatory, given by the client, because the law is quite clear that only the party opponent may offer a statement of the opposing party, and as such, we would object as being hearsay to the introduction of those statements. Now, having said that, we recognized we at least alerted everyone and the jury so that they would have a better understanding of the March 1 statement, that the officers had in fact talked to Mr. Dassey on 3 occasions on February 27. Only one of those interviews was fully disclosed and testified to by Agent Fossbender. So we don't have any objection to the defense asking general questions about you talked to him on this day and things of that matter. That's certainly fair game, but any attempts to actually introduce the statements or the responses is hearsay because it's not offered by a party opponent. The court. Mr. Freeman or Mr. Edelstein, your response? Attorney Freeman. Judge, essentially what we're attempting to do is respond to what's already been somewhat opened by the state in their direct. The state referenced speaking, or the witness referenced speaking with the defendant at Mishicot High School on the 27th of February. I believe he actually testified that he took an audio taped in a statement not unlike the November 5 interview in Marinette, and that he even referenced the videotaped statement at Two Rivers Police Station. The witness was asked if he felt that Mr. Dassey had said everything he knew, and the witness said no. And I don't know, give a couple more examples and I'll essentially wrap it up. As the inference by the testimony to the officer is that Mr. Dassey was not truthful to them on the previous attempts to interview him or left things out. For instance, the officer specifically testified that the defendant denied being involved in the offense on February 27. The officer indicated that he was well, I don't know if he said he was confident, but I think his testimony was essentially, I didn't believe him. I think he was more involved than he was leading on. In the May or the March 1 statement or the video statement, there's references to specific questions or specific answers from the previous interviews. For instance, I believe the 2 pages I wrote down were page 556 of the transcript and page 604. One dealing with the clothing, the color of the clothing, and the other for, I believe the officer said, well, on Monday you didn't say anything about threats from Stephen. So essentially what on direct and through the March 1 video, the state has offered the fact that there had been 2 prior, more formalized statements other than the one that Agent Fossbender testified about at the Fox Rivers Resort later in the evening. And there's been reference that these statements were not entirely accurate, raising my question of whether or not Mr. Dassey was truthful with them. And I think what it does is essentially leaves the jury with questions about this February 27 statements. I believe that we should be entitled to explore this avenue since the state has opened the door to offer a full explanation about the February 27 statement and why they were further discussing with the March 1. Otherwise, it's left, well, essentially, what's left is the state's been allowed to let the officer explain his role, the prior taped statements or questioning, and offer his opinion about the prior taped statements, even though the best evidence is the actual statements themselves. So I think we should be allowed to explore that for the lack of a better argument, or back of a letter term, the state's opened that avenue or opened the door to those questions. The court. Well, other than the remarks that you cite on page 556 and 604, are you suggesting that there are other statements that you wish to discuss? Attorney Freeman. Well, the general tone of the March 1 is that you weren't telling us the truth before. That was the testimony of the officer on direct. We weren't getting the truth from Mr. Dassey. He wasn't telling us everything. He was leaving things out. But in essence, he's saying now March 1 is the truth. Well, I think we should be allowed to explore those prior statements. What was left out? Why do you have the impression that something was missing? And I think part of that's going to be there were different stories or different answers to the same types of questions on March 1. The court. Mr. Fallon? Attorney Edelstein. Your Honor, if I might add, just for the record, additionally, there was testimony. This jury was led to believe by the testimony that there were no promises made to Brendan. Now, I believe we're entitled to question whether or not there were promises made to him at any other interviews, including the 27th of March. Attorney Freeman. February. Attorney Edelstein. February. Attorney Fallon. All right, now I have even more responses to make, both legally and practically. Let's start with the trees, and then we'll move to the forest. First, as the March 1 interview revealed, the actual questions we previously referred to are identified and discussed in the interview, and this officer can be questioned about those specific responses on March 1. So that's 1. All right, number 2, when it comes to admissibility of statements, whether they're custodial or otherwise, the statements are taken at face value at the time and place in which they are given. I'll give you an example. There's a case out of Racine called State v. Pischke, P-I-S-C-H-K-E, that deals with reinterrogation of a custodial suspect. I cite that case just for one distinct proposition, because if the proposition holds in that circumstance, it clearly applies in this circumstance. And in Pischke, there was a series of custodial interrogations. The defense objected because on the last interrogation, the defendant confessed. The defendants floated the idea that the state was the grand initiator of all those previous discussions the 2 days beforehand. And the court said that's a great theory, but it doesn't hold water because it's just about the statement which resulted in the inculpatory events or rendition. I bring that up because that was a gentleman who was in custody, and it was a series of discussions over a 2 or 3 day period. There were several. And the court said it was only who initiated the discussion at the time that led to the inculpatory statement in making the determination as to whether this was a proper reinterrogation. And since the defendant in that case had initiated it, it was a proper. I bring that up by analogy here because we have a 2 day time lapse. The March 1 statement must be and should be analyzed individually as to the events of that day and the circumstances surrounding the giving of that statement. So on that regard, I don't accept as a proposition offered by the defense that what occurred on February 27 has much, if anything, to do with any inducements or promises with respect to what occurred on March 1. Now for the big picture, the forest, the reason behind the rule is to prohibit a party from getting in an version of the events without having to take the stand. And that's why the rule is crafted and structured around. It's an admission by a party opponent, and only the opponent can offer the statements. Thank you. The court, defense, do you suggest that Mr. Fallon's characterization of the rule is incorrect? Attorney Freeman, I would say that the analogy is incorrect as far as this case is concerned. That Pischke analogy that Mr. Fallon presents, it essentially would leave the state with every opportunity to make one attempt after another to interview an individual until they get what they want, and then just introduce that one statement without any reference to the past, even though, especially in this case, February 27 was certainly a primer to the March 1 statement. In particular, many of the questions, not all, but many of the questions were similar but with different answers. The court, well, here we could probably discuss this well into the night. My understanding of the rule, and one of you cited as a case a couple of days ago called State versus Pepin at 110 Wisconsin 2D 431. And here in this case, let's be clear, we're not talking about a custodial interrogation on February 27. If I recall, the parties, and this predated your involvement, counsel, in the case, but the parties stipulated that it was not a custodial interrogation. But anyway, Pepin says that in instances such as we're faced here, that the state has a right to use the inculpatory statements under 90801 4B1, I believe is the statute admission by party opponents, but that the defense does not have the right to use an exculpatory matter that may appear there unless the exculpatory matter is so entwined with the inculpatory matter that it bears the same trustworthiness or same guarantees. I can't say that in this case. I don't think that situation, the trustworthiness of the exculpatory statements here stands out. Thus, I'm going to grant the prosecution's motion here, with the exception, I believe, those were the matters on pages 556 and 604. You can go into those if you wish. Attorney Edelstein, Your Honor, if I could just, before we bring the jury back, I want to make it quite clear that while I don't necessarily agree with the ruling, I can abide to it as to answers. But I fully intend to ask this officer about questions he asked this young man on that date. I'll stay away from the answers. I want him to tell this jury whether he asked him certain questions and the manner in which they were asked. This defense, we are entitled to present our defense. We have raised this as a matter of suggestibility. This interview of the 27th is replete with conscious efforts, I believe, and it's ultimately up to this jury to decide whether or not these officers manipulated and suggested answers to the defendant. Now, maybe they didn't get them on the 27th. Maybe they got them later on, but they have to decide that. And I can cite instance F, and they weren't just generally speaking. They were very specific. Did you have anything to do with Teresa Halbach's death? Some of the other statements they made, the promises. They've led this jury to believe there's no promises. The court, well, here Attorney Edelstein, unintelligible. The court, I get it, and we'll cross that bridge when we come to it. I've made a ruling. Let's get the jury back in here and let's move on. Jurors in at 3:24 p.m. The court, be seated. Counsel, you may resume. Attorney Edelstein, thank you. Detective Wiegert, on direct, you described for the benefit of the state and the jury different techniques that are oftentimes employed in the interview of individuals, correct? Yes. All right, one of those you described as the superior knowledge tactic, right? That's true. And one you described in an effort to the goal being to, quote, take defensive layers off, right? That's true. And I believe you used the phrase to befriend the interviewee. Yes. All right, so in connection with that, it wouldn't be unusual for you to say or say things intended to have this individual like you. Yeah, that's the goal. And it wouldn't be unusual to say things to have the individual believe you, right? That's true. Okay, now again, going back to the 27th. Well, before we get to the exhibit, is it fair to say that as part of this process, and I'm speaking of the 27th, that you and your partner utilized a technique by directly appealing to the emotions of Brendan Dassey? I think that would be fair. And you did that how many times, if you know, on the 27th? I have no idea. On the 27th, there were very distinct lies told to the defendant, were there not? We'd have told the defendant many untruths, yes. Any idea how many? No. Now, as of November 15, 2005, you knew from Eisenberg, the forensic pathologist, that there were gunshot wounds to the head of Teresa Halbach, correct? I can't comment on the date without seeing a report with the date on it. It was in that time frame, I know that, but the exact date I don't know. Attorney Fallon, excuse me, did you say November 15, 2005 or 2006? Attorney Edelstein, I believe 5. The witness, well, that would be incorrect then. Attorney Edelstein, prior to speaking with Brendan on the 27th, well, let me ask you this. Were you present when the statement was made to Brendan? And it might help you, I haven't marked this quite yet, but could you take a look at this? And if you can, tell me if you know what it is, and mark it with whatever the next number is. Sure, it's a report of the interview from November 27, 06 of Brendan Dassey. Okay, does it also contain a transcript of the reported conversation between yourself, Fossbender, and Brendan? It does. Okay, and for the record, we'll mark that as 215. Sure. And that's something I take it you've had an opportunity to review before? Yes. Directing your attention almost to the bottom of the middle paragraph, if you will. First of all, you were present throughout this entire conversation, we'll call it? Yes. Okay, does it not reflect the statement made in your presence by Agent Fossbender directed toward Brendan Dassey? Quote, truthfully, I don't believe Stephen intended to kill her. Do you see that? About 3 lines up from the large middle paragraph? Sure, yes. Okay, and that was said to him, wasn't it? Yes, it was. Is it fair to say that that was said in connection with an attempt to persuade him that it was important for him to give you information and that you and Agent Fossbender didn't really think he did anything wrong, but that some other people might have believed that he did? I don't really follow your question. If you looked a little bit further up there, okay, do you think just take a little bit here and read that one paragraph so I can ask you my next question. I understand you've had a lot of interviews. It's hard to remember everything. Did you get a chance to look that over? Sure. Yep. Good. Would it be a fair characterization then, in the early portion of the contact with Brendan that day, that there was an effort on the part of yourself and your partner to convey to him that the two of you didn't necessarily think he'd done anything wrong, but there were some other people talking like he was, and you didn't necessarily agree with that? Is that what we're trying to convey? Yes. Yes, all right. In this paragraph? Sure. Yes, in an attempt to gain his trust? That's what we do at interviewers. Yes. And confidence? That's what we do as interviewers, yes. He was told, and I'm on page 443, about halfway down, you were present when he was told, quote, you have to tell the truth. You have no choice in that, correct? That's what it says, yes. All right. In fact, as a part of that particular discourse, Agent Fossbender went so far as to say, quote, there's nothing more I'd like to come over and give you a big hug because I know you're hurting. Remember that? Yes, and I think he meant that. The very last line in that exchange, it contains a promise, doesn't it? There's many promises made, yes. So the truth of the matter is, Investigator Wiegert, that on the 1st, when you went to see Brendan, that was somewhat of a follow-up to the events on the 27th, correct? Every successive interview that you do, you build off of the previous one. Information that you learned on that one, when you get more information, you build on it. All right, and it's not just information, but it's techniques. The techniques vary from interview to interview, correct? I don't think the techniques varied at all in these interviews, no. Well, let me ask you this. You watched this video with us today, right? Yes, sir. At different times, placement of yourself and Fossbender changes, doesn't it? No, that's not true. I move over to the couch by Brendan to have some pictures drawn. That's the only time any placement is moved. Okay, that's the only reason you went over there by the couch by him? Yeah, so he could draw pictures. Didn't you go over there so you could kind of cozy up to him and give him this? A pat on the back like we saw on the video? I don't know how I'd have him draw pictures from across the room. I had to go over there and hand him things.